Good afternoon, and welcome to part 3 of our special series from Time to Talk with Jen Graziano entitled Aging in the COVID Era. Each week, we focus on a topic that relates to seniors and their families and important information that they need to know, and also information that they may have known previously but now has undergone several changes in light of COVID. Today, our focus is on estate planning during and also post-COVID. And the expert I am joined by is J.Galvin, a partner at Cassin, which is located in Westchester County, also with offices in the city. And she is the practice chair of their Trust and Estates division. I've been working with Mari weekly on a special senior provider network that we have joined. So I fully vouch for her and the information that she's about to present. And I welcome you, Mari.
Hi, Jen. Thanks for having me.
Thank you so much for coming on. So as you know, we talk weekly. We talk with financial experts. We talk with nursing home administration. We talk with other attorneys. We talk so much about the ever-changing world that we live in. And for so many people that have worked in an area their whole life, everything has changed. All the things that we took for granted, all of the routine, nothing is really mundane anymore. So much is being developed. And I think what we're starting to see is all of these changes are not necessarily short term. There will be long-term effects to how we think, how we plan, how we strategize going forward. I'm sure you would agree with that.
Oh, absolutely. And some of it is in the estate planning world. Some of it hasn't changed as much as the mindset of our clients has changed, because I think we all feel a renewed sense of vulnerability when faced with this type of crisis.
Understood. And, because the what if has happened, and actually beyond the what if, because this is not a scenario that anybody would have thought of. But I want you to start from the beginning. What are the most common types of legal and financial conversations that you're having with your clients today in the face of the pandemic?
So in the face of the pandemic, we go through our ordinary discussion about the essential tools you need to have put in place. And it's the I call it your safety net, and we can expand and become more sophisticated from there. But every client that I talk to, you need to plan both about the disposition of your assets if something were to happen to, but also start thinking about, the fact that you could become disabled. You may need someone to step in for you for a period of time before you pass away. And I don't think that concept has felt as real as it has now through this pandemic, because an individual should have a healthcare proxy, a living will. Healthcare proxy appoints an agent to make healthcare decisions for you if you cannot. And now we hear in the newspaper about people going into the ICU unit. You can't necessarily talk to them because maybe they're on a ventilator. So this concept and the discussion that I have with my clients about why you need an agent, you can really see them contextualizing and appreciating what it's about. It's very real if it wasn't before. Go ahead, Jen.
No, very true. Who is speaking for you? Because so many people cannot speak for themselves right now. And you have that situation also where there's physical boundaries that separate you from loved ones in a hospital. Right. So that the need for an advocate and someone to understand and execute and be able to execute your wishes is key. And also, I'm sure the need for successors is key. That if the person you designated to perform that duty, we often don't think that person will be unable to fulfill that obligation and that fiduciary duty. But I think this also begs us to think about who's plan B or perhaps even plan C in making these plans.
No, that's right, and that's why you want to go in, see your estate planning attorney, talk to people and your other trusted advisors as well on a fairly regular basis. I know estate planning isn't always top on people's list, and once we get it done, I always say what I'd like to do is make you feel like you can sleep well at night, but I also want to stay in touch with you, because the reality is that people in your lives will change over time. It doesn't mean that the relationship has deteriorated, but perhaps you named your sister and now your sister is working abroad. Perhaps you named a cousin who made a lot of sense at that time to be a guardian for your child, but now they're in a different school system. Your kids are older, they're very much ingrained with a new set of people, and circumstances have changed, and you want to think about what's right now. So constantly reviewing these plans, taking a look at them is very important. And
Absolutely.
yeah, and another thing is also to know where these documents are. Um,
Absolutely. That's, doing them is great, but not
yeah,
communicating their whereabouts is detrimental. And I even see it myself in this realm of work in the funeral home. People need access to this. They need to know
right,
where documents are.
right,
And when you're in a grief type setting and now you're trying to say, okay, where would mom and dad have left them?
right.
So communication is key. And even if you've left everything on file with an attorney, letting people know who that attorney is, so
Hmm.
important.
Hmm. No,
So
you want
important.
to have access to the original documents. If it's at the law firm, know, what law firm is holding those original documents, how many are out there, who has them, and not only so you can use them, not only just understanding who's appointed in those documents, but how do I actually get them? If I have to take it to a bank, if I have to take it to a doctor. And again, I'm going to go back to that change in mindset that the pandemic has brought about, is because people know that this was a possibility, but they're really thinking, oh, I could be called on tomorrow to go pick up this healthcare proxy, and do I know where it is and when?
I think it just, I think, if anything, if there is any positive or benefit, I mean, certainly so hard to find, but I think a mindfulness and an awareness was raised. So
Mhm.
people might be more prudent going forward. And if people had been reluctant to do any planning, this may be the motivating factor. And also, we'll get to this in a second. If you have done your plans, I think you just mentioned this about keeping in contact with your attorney. Plans should always be reviewed, probably every 5 years or so.
Mhm.
So it's not enough to say that you did them. That was great, but you need to review them, like you said, for change of circumstance. But Mari, what are the essential documents that everyone should complete? And again, keep in a place that's easily retrievable. What do we all need to have right now, regardless of, if we're of a senior status? What do we need?
Right. So, and I guess I began to touch on it. So, you want to think about appointing people to take care of you if you can't make decisions for yourself, but you're still here. And those essential documents is the healthcare proxy that I mentioned before, where you're naming an agent to make medical decisions for you. And then the other document is a durable power of attorney, where you're naming an agent who can take care of your finances if you're unable to do so yourself. Um, that is the safety net that can get you through that period of incapacity. There are more elaborate ways and trust arrangements that can also serve in terms of taking care of your finances if you're incapacitated. But when you could talk about the essential documents, it's a durable power of attorney is one of those essential documents. Healthcare proxy. If something were to happen to you, what you do want is a will or a trust agreement that states your wishes to in two categories. One is how to dispose of your assets, and also who's in control of disposing of your assets. Both of those concepts are very important to think about. The disposition of your assets sometimes is a little bit easier in people's minds, because they often say, well, divide it equally among my children, but you may have special assets that require special care, especially for our people that own businesses, and they need to have a succession plan in place there. Um, but then in terms of who's going to control that distribution of assets and carry out your wishes is also important. If you have several children, family dynamics play a part in deciding who is an appropriate person and making sure that not only are they capable of managing that process, do they have time to manage that process, and how does that impact the feelings of the other people, their siblings. So there's a, a lot of conversation goes around making that decision about who's your executor, and if there are trusts, who would be the trustee as well.
So, Mari, tell us a bit more about how you and your colleagues are advising your clients to be in the best position possible, in a situation like this. This was nothing that you could have prepared anyone for. I mean, nothing you could have seen in advance. And I have to believe that in general, preparedness is not even enough here. So, how are you advising your clients to ensure that they are properly situated should this ever happen again?
So I'm going to go back to, just taking care of those essential documents, making sure that they're done, making sure that you're having conversation with all your advisors, making sure you know where your documents are located, and then communicating your decisions with your family members, or if it or other trusted advisors who are appointed in your documents. But it's so what I said earlier is it's not that estate planning has changed dramatically. It's about the mindset and the preparedness. And I think people are taking it a little bit more seriously.
So, I want, again, a distinction that we always hear of an executor, and it's a known term, even if people don't necessarily know the roles and responsibilities that it entails. Can you distinguish for our viewers today the difference between an executor and a trustee and what their fiduciary responsibilities are, how they differ?
Sure. So the executor is appointed by the court when the will is admitted to probate. The job of an executor is to marshal the assets of the decedent, and these are probate assets. That's assets in the individual's own name. It does not include jointly held assets. Jointly held assets pass by right of survivorship to the joint tenant. Um, it does not include life insurance because you have a beneficiary designation form on file. Unless it says payable to my estate, it's going to be paid directly to the beneficiary. The same is true for qualified retirement funds, unless the beneficiary designation form is appointing either your estate, which you wouldn't want to do, but that's not your question, or trust under your will. So the executor is going to marshal the assets of the decedent, pay all the expenses, the debts of the decedent, the funeral bills, taxes, and really steps into the shoes of the decedent to wrap up his or her affairs. And I say it really has a beginning and an end. Typically, an estate administration runs about a year. It doesn't happen quickly. And I tell my clients, think of this more as a marathon than a sprint, because you're going to exhaust yourself. There's just a lot of little pieces. We think our lives are very simple, but yet someone has to file that final income tax return. And if there's a refund, collect the refund check, file an estate tax return if that's required. So right there, you can see, well, if someone were to pass away at the beginning of 2020, his income tax or her income tax return is not going to be due until April of 2021. You can, sometimes file sooner, but it is a process, but there's a beginning and an end to it, and it will finally settle either informally or judicially. And the assets are all the expenses, taxes, obligation of the state are taken care of. Then all the remaining assets are paid out to the beneficiaries, and the estate settles and it is closed. It's a separate tax entity. It has its own tax ID number. It has its own fiduciary income tax return that's filed, but it will settle at some point in time. The assets are distributed out, and the executor's job is done. So a trustee is a person that is going to administer assets on behalf of another person, and a trustee can be administering trust assets that came out of the will. So the executor, when I say he's wrapped up, paid all the obligations, he's wrapped up his job, may take that net proceeds, the residuary estate, and pay it into a trust either for the surviving spouse, or if there isn't a surviving spouse, it could be a trust that the decedent created for his children, for either a period of time or for that person's the children's lifetime. The trustee has an obligation to those beneficiaries for whatever designated period of time, will manage the assets, take care of all the tax returns that the trust has to pay, and administer it according to the wishes of the decedent. And the trust can also be, it's not always a testamentary trust. We refer to trusts that are created in a person's will as a testamentary trust. People often have lifetime trusts they could fund during their lifetime and that go on after they die. So if a person had a revocable trust or another type of trust that he or she was a beneficiary of, sometimes upon their passing, there will be continuing trusts for children, surviving spouse, or others, and a trustee will administer those assets for that period of time. So it's very different, an executor's role and a trustee's role, because a trustee takes sort of a clean slate. It has a lump of assets that are distributed and deposited into a trust account and administers on behalf of those named beneficiaries for a period of time. The executor is involved in a more, I was going to use the word detailed, but that sounds like I'm taking away from the trustee's job. There's a lot of details for a trustee, but an executor, you think more of that person is just stepping into the shoes of the decedent, wrapping up affairs, and then transferring the assets out to the beneficiaries, whether it's outright or to a trustee.
Well, it's a very good distinction that you provided for us, so I thank you for that. But let's go back to, again, usually family is named in these, doesn't necessarily have to be that a family is appointed in these roles. But let's talk about family conversations. These are sensitive topics. Nobody wants to discuss these scenarios because they often imply end of life or an incapacity or inability to do something. And no one wants to think about that. And the irony is that these conversations need to be had when you're happy and healthy and thriving and think that life will never change. So it's a very hard balance. But what are the family conversations and planning that are sometimes overlooked? I mean, you have situations between siblings. Often, you have one that might be the closer caregiver, one that might have more decision making. You have successive marriages that, you have dad remarried her and kids don't really like her. I mean, there are real things that happen, division of assets. What is often overlooked and left unsaid, and what are the dangers in that?
Well, family dynamics, every family is unique. So, and I don't know that all my clients appreciate how important their role as a matriarch or patriarch in terms of keeping everyone together. So, one of the conversations that I do have with my estate planning clients is about the family dynamics and trying to anticipate any type of issues that may come up. And oftentimes this conversation comes up when I'm talking to them about who do you want to appoint as your executor or trustees of trusts. It's a difficult for me to always pinpoint what's left unsaid because you don't necessarily have the whole family come into your office. On occasion that may happen, but I obviously have attorney-client privilege with my clients, and I do tell them that it's important that we maintain that privilege. But if we want to have an open family conversation and it's appropriate to do so, I have had family members come into the office and we have more of a group discussion about things. But what I try to impress upon my clients is letting their children know, again, what is their general plan, who's appointed, why they're being appointed. But I do know, because I've gone from the planning side to the other side where the person has passed away, and now I am working with the family and trying to effectuate the plans. I don't know what has been said or not said, and it's hard to it's sometimes hard to navigate those type of issues. But the main thing is that we as a law firm are here to give them the legal advice and help them understand what the duties, what the roles are, what mom and dad wanted, and generally we can navigate and get them down through the path and get the wishes carried out. But
it's a delicate balance of legalities, legalese, and human emotions. I mean, you're really playing with all of them in that realm. So, while you have your legal duties and your attorney-client privilege, there is somewhat of a social work component to what you're doing that can't be underscored. So again, this all begs the need for sitting down with a trusted, understanding, and knowledgeable trusted estate's attorney. And I'm always an advocate of not to leave this realm of your life to the hands of, a more general practice. The need for specialization is paramount here.
Yes. Oh, sorry, Jen.
No, go right ahead, Maury.
I do, and I do think, that if you really have these conversations and really work through them, though, you're going to have as smooth of an estate administration as possible. What you don't want to see happen is the family falling apart because something was left unsaid. And I'm going back to the patriarch matriarch, understanding how to keep the family together.
Mm-hmm.
Post.
And it's true, and that's always the goal. I mean, I think it's one of the saddest things that I see when it falls apart in the aftermath of loss. Loss is hard enough, but when it brings about a casualty like that, I think it's just so much more compounded. So we're going to circle back because there's a lot of great information you're giving us, a lot of ways that we can dot the I's and cross the T's. And we've referred to this a few times earlier in the show. It's great to do it, but if nobody knows where it is, then it's all for naught. Where do you advise your clients to keep the will, other important documents? How do you go about that conversation?
So at our law firm, we generally offer our clients the choice to leave the original will with us. We do have a will vault. Not all T&E attorneys want to keep original wills. We happen to maintain a will vault. So the original is generally left with us. And then we give a conformed copy to the client. If sometimes the client says also send it to my children so they know what's in the will. But there is only one original will. And if it's important, if you're not going to have your lawyer to take custody of that original will, you have got to let people know where it is. Do not put it in a safety deposit box. Generally, those safety deposit boxes are sealed. People often think, well, that's where I should put all my important documents, but it's not easy opening up a safety deposit box. So then it begs the question, where's an appropriate place in your home? If you're not going to put in a safety deposit box, do you have a secure place that someone else would know about or access? Sometimes, I don't know, Jen, if you've ever done that, when I think of, I want to put something in a safe place, I put it someplace special, which then I'm like, man, where was that special place? And then
many times, familiar conversation. Yes.
Yeah. So then you find it down the road and you go, oh, I now I remember that was that, why I thought this was going to be a particularly safe place, but it turns out to be an unusual place that no one can remember where it was put.
But sharing the location, it could be a special place, but sharing the whereabouts of the location with the people that are relevant to it. You don't have to tell everybody, but the people that will need to find it should certainly be part of the process of scouting out the location, I would say.
Yeah. So there's only one original will, and so that's why that's so important. But you can have more than one original healthcare proxy and power of attorney. And generally, in my practice, we'll execute 3. I'll keep one original. 2 go to the client. The client will keep one original and give an agent, the successor. Typically, if you're dealing with a couple, the surviving spouse will have access to the one that the client has. But then the second original that I give to the client goes to the successor agent. So and I know you mentioned before about having the successor. So if something were to happen to husband and wife, the successor already has an original and can come in if it's the healthcare proxy as well as a power of attorney. So we generally execute at least 3 originals. And I can tell you, even though we do 3 originals, it lengthens the execution process, but not by that much. And oftentimes when I have clients come back in and I tell them, well, gather your originals and we'll execute new ones. They don't know where they are, but I do have one in my will vault, and I have been called on a weekend to go into the office, get the original, and go to a hospital. So I'm always a safety net for them. If they can't find it or their agents can't find it, I'll have one of the originals.
So, Mari, what are some other best practices, if you will, for estate planning that you want to share with your audience? Again, wonderful information so far, but what are some pieces of advice that maybe we haven't touched upon?
One thing that we haven't talked a lot about is making sure that your plan doesn't involve just your trust and estates attorney, that you're getting your financial advisor, you're getting your insurance agent, so you coordinate your plan. I mentioned that when a will is probated, the executor collects all the probate assets, but I mentioned the non-probate assets. And it's important that those assets are considered in the overall plan and that everyone understands how title of assets matters. So once you've done your will, it will control only those probate assets, that you consider the non-probate assets, and that everything is coordinated between all of your advisors. And I think that it's exhausting sometimes to think about, but if you can go the whole 9 yards and get everyone involved, it really does help make your wishes carried out at the end.
Again, we mentioned earlier, perhaps, heightened awareness, mindfulness, planning, and preparedness are positives. I mean, what are the positives you see coming out of this pandemic? We're so hard pressed to find them. I mean, there's really nothing good about life these days, but from a legal perspective, what do you see as the positive changes that will be effectuated?
I think number one, it's a wake-up call, and I think people are being very conscientious about the decisions they're making, realizing that what I do today may be carried out tomorrow, and especially in the younger age groups, I think they're considering their estate plans more seriously than before. But there's a couple other things that will be interesting to see, because there are executive orders in place now that have allowed people to execute wills and trust agreements, healthcare proxies, powers of attorney using remote witnesses and notaries. Those executive orders are going to expire June 6th. But I know there's discussion going on about, should we allow more remote witnesses, notaries, online services.
It is interesting. I mean, it's doable, and everything in the world is at our fingertips, and it might make, it begs the question of how unnecessarily antiquated our system is. However, the flip side of that, all of the extra precautions that we take with witnessing and proper notarization is to ensure the legality of the documents, is to ensure that the person who is creating them does, in fact, this is their intention. You do see the room for undue influence, duress, error. You do see that. So that's a very tough legal balancing act.
It is, but I think it's because we're looking at the world out of a new lens. We're having these conversations again, and it's also a reminder why we have them. I have I work at a mid-sized law firm where a lot of our work is involved with residential and commercial real estate transaction, and everything is done online and whatnot. And I still have my paper. I even am old school with the ribbon, and I've always felt
I'm with you.
a little bit old-fashioned in a sense. But
Totally.
to your point, there was a reason behind that. So when you have a remote witnessing and notaries, you do think about, well, is there someone else in the room? When I have a will execution and everyone's in the room and they're signing a piece of paper, I have control over the entire environment. I have private conversations with people and I look them in the eye, and that this is their wishes, their capacity. There's and I'm not going to go through all the formalities of will executions, but there's a reason why those formalities exist. And I think we're, again, saying, well, are those things still important? Are there changes, innovations such as this remote that is now going to outweigh the benefits and some of the risks that we had before? I don't know how all this is going to, come about. There are some states that allow digital wills, but again, it's a renewing of the conversation. And we have this opportunity with a new lens to say, what can we take that's good out of how we've had to operate in the last couple months, and say, do we want to continue this going forward? And like I said, we may say, the way we did it before is there's a reason behind that, and we should continue the old-fashioned way, so to speak. But the fact that we're looking at everything with these new eyes, this new seriousness, I think is wonderful. I think some things will change and some things will stay the same. But the conversation is always wonderful.
Again, it's balancing convenience, technology, and security and validity at the same time. So I agree. I think at least the dialogue has begun. And again, if we want to try to keep a positive perspective, maybe it just offers us a way to do that. Mari, are you seeing clients call you with more frequency, a lot of panic, or do you find that the dust is starting to settle now?
I would say the dust is starting to settle now. The first 2 to 3 weeks that we went remote and everyone sheltered in, there's a huge rush to get things done. I had a lot of clients that I was working with that were partway in the process of estate planning, and we got all those people in, got everything signed up and taken care of. And so there was a huge rush at the very beginning. Towards the middle, I guess after about the first month, I was working with a lot of people who, and I'm trying to think the date the executive order allowing remote witnesses, but when that opened up possibilities, we were working with people who are in New York City, some healthcare providers as well. So it was a new kind of busy from people that needed new estate plans, and now things have calmed down a little bit, and I think there is a little bit of a focus on return to work. So I hope we don't lose those people who are getting their plans together, and I don't think we will. I don't think we're going to really be the same, but the huge rush seems to be a little bit behind me now.
I agree. And I think from all professional realms, we concur with that. Certainly time to move forward. So Mari Galvin, once again, you're a partner at the firm of Cassin and practice chair of their Trusted Estates division. You serve clients in Westchester and New York City. How can people access you directly if you want to? I think your phone number is displayed, but if you want to provide an email address or recite it out loud, because it is small print, admittedly, I'm struggling.
I still have my glasses on, but it's so my direct dial is 914-517-6906. You can always reach me on that number, or you can send me an email at mgalvin@cassinllp.com.
And again, working with somebody as knowledgeable as you is only going to yield positive outcomes. Estate laws vary state to state. There's so many different facets of estate planning. So many people have secondary residences that it becomes an issue of what becomes the primary residence. These are conversations you have to have, and you don't have them necessarily as late as one might think. So you raised a good point earlier. Perhaps this is getting that 30 and 40th generation a bit more mindful of the what ifs and dotting I's and crossing T's. So I thank you, Mari. This is wonderful, very insightful.
Oh, thank you. I appreciate
And
it.
a pleasure meeting with you weekly. I'm sure we'll meet next week again. So I thank you for the information. And this is Jen Graziano thanking you for taking the time to listen as we took this special time to talk. Have a great day, and we'll be back next week with the final part in our series, Aging in the COVID Era. Bye-bye.